This is a lecture from my professional responsibility class. And in this short video, we're going to talk about types of conflicts of interest. Now, most of the lectures we do are focused on the model rules themselves and the comments. But in this video, I want to talk about, to try to picture the types of relationships or representations we're talking about with clients when we go through the comments or talk about the conflicts of interest. And so our simple scenario, our sort of classic scenario is that I'm going to call type 1 simple, is a lawyer has already been representing two clients, Greenacre and Redacre, on unrelated matters. And then a conflict arises when a new unforeseen legal dispute erupts between Greenacre and Redacre, and they both think of the lawyer as their attorney. So even though you were doing separate legal work for them, let's say they got in a fender bender or have a property dispute or something like that, and each one says, I'm calling my lawyer, and they're both calling you. So obviously you can't represent both. You have a conflict of interest, and that's sort of our classic scenario. A variation on type 1 simple is you've been representing Greenacre for a while, doing, let's say, small business type legal work. You review contracts and vendor licenses and leases and things like that. And so then Redacre comes in and says, I want to sue someone, and it's Greenacre. And even though you aren't going to represent Greenacre, let's say, doesn't use you for their litigation, they are your client in other legal matters. And so even though you're not trying to be the lawyer for both sides in this case, both parties do use you as their lawyer on some occasions, and so therefore you have a conflict of interest. A more complex variation on this, of course, is more more realistic, that you have a lot of clients, Greenacre, Redacre, Goldenacre, Grayacre, and Pinkacre. You represent all of them on unrelated matters. Maybe you do wills for all of them, or contract review, or leases for all of them, or litigation for all of them. But a conflict arises when a new unforeseen legal dispute erupts between Greenacre and Redacre, and they both think of the lawyer as their attorney. If some of your clients know each other, which may not happen, but sometimes people have referred, some of your clients have referred people to you who have then become your clients, which means you have clients who know each other. And so then it can get very complicated, because you could have other clients who have an opinion or are sort of taking sides in this dispute that has arisen between two clients. Okay, next, let's talk about another completely different type of concurrent client conflict of interest. And this is where the lawyer is representing co-defendants or co-plaintiffs at the same time. It could be 2 or 3 or 4. And in other words, you have people who it's the same matter and they're on the same side of a case, but they are sharing a lawyer in their court case. This could be a civil case where you have co-plaintiffs, or co-defendants. Let's say an employee who's being sued along with their employer, who's being sued and sort of for vicarious liability. This could be co-defendants in a criminal case, the person who held up the convenience store and their getaway driver, or their co-conspirator, and so forth. And so hopefully you can see that conflicts can arise in this type of situation. By the way, the ABA model rules tend to describe this type of client, what I'm calling type 2 conflicts of interest, as joint representation. So I will often call them co-clients, because I think it's a little more colloquial, but the ABA calls it joint clients or joint representation. And a conflict can arise when some of these parties file cross claims against each other, and as you probably learned about in your civil procedure class. And that can happen for a variety. It could be that there's two people who just happen to be listed as co-defendants in the same case, or co-plaintiffs, but they actually don't like each other that much or have any other type of relationship. It could be that one side's insurance company is trying to, wants to include as many defendants as possible. A cross-claim could actually be a sneaky way to try to change jurisdiction for the case or something like that. Even more commonly, it's very foreseeable that if you are representing co-plaintiffs or co-defendants, that they could disagree about whether to go to trial or settle, or disagree about the settlement terms among themselves. And so the plaintiffs may be willing to settle, but they may disagree on how much they're willing to settle for, or who gets what share of what's paid. And the same happens with co-defendants. You have one lawyer who's representing them, and then you have someone who who wants to take their chances at trial, and another one who is in a big hurry to settle the case, or the other opposing party offers to pay a payout, or actually offers an amount that they'll accept, the plaintiffs, and the co-defendants then start arguing among themselves about who should pay what share of that. Also keep in mind that if, especially in criminal cases, that co-defendants will often be offered a deal, a plea bargain, to testify against each other. This puts the lawyer in a very difficult position, because let's say one of your clients, you're representing two co-conspirators, one of them is offered an amazing deal. They'll drop the charges, or no jail time, just probation, or something like that, if they'll testify against the other. Well, if you were only representing that client, you would tell them to take the deal because it's better for them than the risk of going to trial and getting a long prison sentence. On the other hand, you would be counseling them then to testify against someone else who is your client, to testify against your own client, and you can't do that. So this presents a conflict of interest. Type 3, what I'm calling type 3 conflicts of interest, are there's a group of individuals, it could be two, but I have on the slide 3 or more, ask you to help them, let's say, create a partnership or a business together. So here, the parties don't think that they are adverse. We don't have people suing each other. They're not suing anybody else. They're actually trying to have you do legal work to form a legal union between them, or some sort of compact or association between them. This could also be spouses who come in and want you to draft their will, a joint will, where each of them leaves everything to the other spouse if they die first. And but for now, let's say it's our business people, and you could have a situation. Here's our kind of classic archetype narrative. One of the people helping start the business is putting up a lot of the money to get it off the ground. They're wealthy, and so forth. And then you have someone else who's the brains of the operation, or has the big idea. They're the inventor or the visionary, or maybe they're just the famous person who's bringing their name into it for branding purposes. And then let's say the third person in our cast of characters who comes to the lawyer is the workaholic kind of hustler who's going to work 24/7. They're actually doing the work to get the business off the ground. And I hope you can see that eventually a conflict will arise when one or more feels that they deserve a greater share of the profits or control due to their special contribution. So the person who has put in the most money out of pocket of their own is going to say, I should get paid first, or I should get all the money I've already put up paid to me before we start dividing up profits, and so forth. And the others could say no. And so then the person who's bringing the talent or the big name or the big idea is going to say that none of you would be here except for me. I'm the reason that the company exists in the first place, because of my idea or my fame, or my vision or my personality or something like that. And so they expect a greater share, or a generous deal when they leave the partnership, and so forth. And then of course the person who's done more work, just in terms of hours of labor, than anyone else, and very often there's one person who does way more work than everybody else, they think they should be paid more. And then the person who's been, say, a passive investor, or the person who just sits around having big ideas, or something like that. So here's another scenario. Let's say 4 musicians, we'll call them John, Paul, George, and Ringo, come to you, the lawyer, because they've had some successes, they've sold some albums, and now they want to start their own record label. And they want to call it, hypothetically, Apple, so that they can have 3 decades of litigation with a computer company and that's using the same name. Just kidding. And so and you say, okay, so how do you want to divide things up, or how do you want to share things? And they say, look, we're going to stick together for the rest of our lives, and we want to divide everything evenly. It's one for all and all for one. Well, here's the problem. If you start talking to them and listen to some of their songs and their albums, you realize that 2 of these individuals are extraordinarily gifted songwriters. So they just have a way of weaving music and words together so that it's catchy and it sticks in people's head. And 50 years later, people are still going to be playing that song on the radio or listening to it and recognize the song and know the whole song by heart and so forth. And so they're talented, outstanding in their generation, really, for just a very, very gifted songwriters. And then you have the other 2 who are good musicians, but might be interchangeable with other people from the band standpoint. So the drummer, Ringo, we'll call him, he's a good drummer, but he's not the band's first drummer. They had another drummer, Pete Best, before Ringo, and if something had happened to Ringo, they probably could have gotten another drummer who was just as good. And so, by the way, Ringo had a long, distinguished career after this band broke up, narrating the Thomas the Tank Engine TV shows for children that you may remember from your childhood. And then we have George, don't forget George, also pretty good songwriter, pretty good musician, not in the same league as the other guys though. And so it's completely foreseeable for you as a lawyer from the day that they walk into your office that there could be a dispute in the future, even though today they want to divide everything evenly, that later on, some of them are going to feel like, people are really coming to see us because of me, or because of me and this one other person, and everybody else, we could kind of switch out without a problem. And then there's a whole other issue of the Yoko factor, right? That at some point one of them gets a new girlfriend or spouse or someone in their life who turns everybody against each other and messes up the whole situation, and then they want to break up. And the question is, they didn't really anticipate going their separate ways at the height of their fame. So the lawyer has a conflict of interest. Now, you may remember from 1.7 A that it kind of created 2 big categories for concurrent client conflicts of interest. And just to review for a moment, we have directly adverse clients. And as a reminder, a simple way to think of direct adversity or direct adverseness for purposes of conflicts is doing something that benefits one client hurts another client. And so this could be a transactional work where one client is going to make more money, but that means the other makes less. It could mean helping another person win their case or get a better outcome in court, which because they're directly adverse means the other one will have another client who you may represent on another matter, but it's to their detriment. And so that's one simple way to think of, are the 2 directly adverse? The question is the benefit that one client hopes to obtain from the representation going to injure or be to the detriment of another? The second big category that 1.7 created for conflicts, though, was called material limitation. And here, it could be a situation where what you're doing for one client might actually have no effect, or might not harm another client, but that other client, for whatever reason, is able to influence the lawyer's judgment. So the lawyer, you can think of material limitation as essentially a bias or a perverse incentive or something like that. This could be the lawyer's personal incentives, right? The lawyer has strong personal feelings. They're politically opposed to something or passionate about an issue, or they've had a horrible experience, right? All of these things that could cloud the judgment and the professional objectivity of a lawyer are what we would call a material limitation conflict. So let's look at my funny little diagram here for just a moment. So let's say the lawyer is here and we're talking about the clients, and I want you to see that not all clients are the same when you're in practice. You're going to have some clients that give you a lot of legal work and maybe they pay really well, they pay all their bills and so forth, and your firm kind of, they're an anchor client financially for you. And frankly, if there's even tension, not direct adverseness, but they may affect how you think about or how you prioritize a smaller client who's a one-off person, or somebody who's doing something that doesn't generate a lot of fees, that the representation they need could even, to be honest, be a pro bono client, someone you've taken on as for pro bono work, and now you have a problem because there's just some tension. Or it could be as simple as the fee-paying client takes up all your time, and you sort of end up shortchanging the pro bono client because that's a freebie. And that is a type of material limitation, someone who demands your time or demands your attention or drains all your emotional energy or something like that, so that you are not providing the full, competent, diligent representation for someone else. It could also be a personal dislike. So you represent, you have a very lucrative client who is basically you're financially dependent on, and they're mad that you've agreed to represent a protester who burned a flag outside their building. And even though there's no legal dispute between the two of them now, they're not directly adverse, the one resents it that you're the lawyer for the other. We could also have material limitations with the potential client, who I'm calling in this diagram new client B, right? So you want to represent that person, but you have a problem because of this client you're already representing, and it can start to bias you, and where you would rather do something to kind of limit the effect that one client is having on you, or one client may be affecting your ability to take on new clients. And if you watch the show Better Call Saul, as you get into the later seasons of the show, there's an attorney in the show named Kim Wexler, who for a part of the series has a big client, which is a bank, a local bank in New Mexico, and they're expanding rapidly, and they're using Kim for the attorney, Kim Wexler, for all their legal work. And at some point, she's also doing pro bono cases at the court for criminal defendants at the courthouse, and starts missing appointments or showing up late for depositions and things like that for her big client. And they basically tell her, we don't want you to have other clients if you are doing our legal work, because we want you to be available all the time only for us. Also keep in mind, I have on this diagram the idea that sometimes it could be a financial investor in like a lender, not an investor is the wrong word, the bank who has lent the lawyer loans for renovating their office space and so forth, or has extended the law firm a line of credit. Sometimes they can exert some undue influence, or your malpractice insurer, someone like that, is talking to you about, I think you should say, I don't think you should go take that other client's case to trial, and so forth, just because they have an opinion. And of course, keep in mind that the lawyer can have his or her own personal issues that can be a material limitation. And I want to talk about that for just a moment. So let's say, hypothetically, that you are passionate about a particular cause. And I'll pick a controversial issue like abortion. So let's say that you as a lawyer, you have a lawyer who's passionately pro-life. They've devoted a lot of their free time to the cause of fighting abortion. They believe abortion is murder, and so forth. And they're working in a firm, and the firm asks them to do legal work for Planned Parenthood. And this violates their conscience. Now, there's some people who maybe they feel a certain way, but they could set that aside because they don't care so much that they couldn't provide legal work for someone. But there's other people who do. And we could flip the hypothetical and say you're passionately pro-choice. You have devoted a lot of time to and energy, and you're really invested in the cause of protecting abortion rights. And the firm you're asking, that you're working for, asks you to do some work for some anti-abortion protesters, or someone who vandalized an abortion clinic, or a pro-life pregnancy counseling clinic, or something like that. And this goes against your deeply, passionately held convictions. You might not be the best person to take that case. Another scenario that's a material limitation. You have $100,000 invested in stock in a particular company, and Greenacre comes to your office one day and says, I want to sue XYZ company, and you're invested. Or your managing partner, who you're terrified of, has $100,000 stock in that company. And so this could cloud your judgment if you undertake the representation. And then you have a financial interest that goes against what your client's interest is, then that could be a conflict of interest. Here's another situation that actually happened to me in law school. I was, for a while, before I moved to Texas, my wife and I owned a 2-family house, and our in-laws helped, her parents helped us buy and so forth. And so so there was one apartment that we could rent out to a group of tenants. They were roommates, usually a group of single people, professionals, and that would help cover the mortgage for the other apartment. Very common scenario for like young couples with young children getting their first home, to get a 2-family house so they can have some rental income from one of the dwellings, and that's what we had. Well, the problem is that sometimes you get a nightmare tenant, and we had a nightmare tenant for a while who made all sorts of problems with the other housemates, and constantly fighting and causing problems in the apartment, and didn't pay rent, and blocked the driveway, everything that you can think of, like bad roommate stuff, wrapped into one, like every type of bad roommate situation wrapped into one. Finally, to our great relief, the person moved out. So I was starting law school when this happened, and a few years later, I graduated from law school, took the bar, and went to work for a legal aid clinic, an inner city clinic that provides free legal services for poor people. And as in my second year at the legal aid clinic, I was doing landlord-tenant work, representing people who are being evicted, poor people who are being evicted, and the clinic, a case appeared on my desk, and that of someone being evicted, and I looked at it, and it was my own tenant who I had tried everything to get the person to move out, and was so relieved when they finally did, and had this nightmare experience with this very same person. And now they were doing all of the same things that I had suffered through to their landlord, and their landlord was evicting them. I didn't have to evict the individual. But I want you to think about the scenario. Like, I know this person. I have a history with this person. I had a really, really bad experience that went on for months and months with this person. Was hoping never to see them again. And their case just dropped on my desk. So I took the case, walked down the hall to the managing partner, and said, I have a history with this person. I know them. They were, and it's not just like, this is a person I don't like, but I was in the exact same legal relationship with this person. I was their landlord and they were my tenant, and it was a nightmare. I'm not the best person to be their lawyer against their landlord. No problem. They can just give the case to another lawyer at the agency, at the legal aid clinic, to represent them. I'm not the best person. And I want you to think about for a moment that not only is it possible that I might not do a good job, I might not be objective or provide zealous advocacy, but even if I could set aside my personal feelings and represent this person, if something goes wrong, if the case doesn't go our way, then in hindsight, it's going to look bad, like my objectivity will be questioned when things go wrong, and it will look like maybe you didn't try as hard or something like that because of this. Here's another material limitation. The client comes in and it's your ex-boyfriend or girlfriend or ex-spouse, someone that you parted ways with very badly, and it was a very stressful thing. You hope to never see this person. They're like enemies for life, and so forth. And your firm drops their case on your desk. Well, it's a question about whether you're really the best lawyer to represent an ex who you don't get along with. I mean, let's make an extreme scenario. There's an ex who you took out a restraining order against. That's how bad things were between you. You shouldn't be their lawyer. Somebody else can be their lawyer, and maybe somebody else in your own firm. It's a personal material limitation. That's one type of material limitation. So this isn't even a problem between conflicts, but under the language of 1.7, it also 1.7A2, it would also cover that type of kind of personal situation, your financial investment, your deeply held convictions or religious beliefs or political passions or something like that, or your personal history with this person. Could also be a personal history like your ex-spouse, or even your current family member is opposing counsel. That's a material limitation. You shouldn't be the lawyer. In that case, give the case to somebody else. Otherwise, either you're not going to do a good job, there's going to be all sorts of trust issues, or even if you do a good job, if things just don't go your way, and sometimes they don't in the practice of law, then it will, in hindsight, be attributed to your conflict, to the bias that you're perceived to have had.